Welcome back, everybody. We're going to discuss Chapter 21, and Chapter 21 deals with fair housing and ethical practices in the real estate business. And so as we get going here, we want to make sure that everyone understands that it's very incredibly important that real estate professionals follow all of the fair housing laws and make sure that their practice is in an ethical manner consistent with the state rules and law. And because there's stiff penalties, there's possibility of having a license be suspended or revoked if there's failure to adhere to the federal, state, and local laws related to fair housing and ethical practices. And so let's go ahead and get started here. Equal housing opportunity, is very important, and that's the purpose of the civil rights laws, is to make sure that there's a marketplace for housing whereby people that have similar financial means have the similar choices of housing that meet whatever their particular needs might be. And in Illinois specifically, the Real Estate License Act of 2000 and its general rules require that all licensees fully adhere to the principles of equal housing opportunity. And so that means the real estate company, the managing broker, the brokers, and leasing agents. Every licensee has to follow all of the rules. And that's the federal law, the state law, and local laws in the areas that you're practicing in the state of Illinois. And the Real Estate License Act and rules prohibit a real estate licensee from taking a listing or participating in any real estate transaction where they know that the owner is seeking to apply discriminatory standards, whether it's based on a person's color, race, religion, national origin, sex, or gender, disability, or familial status. We cannot, for any reason, take any listing or participate in any transaction where the owner is going to apply discrimination based on any of these conditions. And if we were to fail to comply with the federal and state and local laws related to fair housing, not only is it potentially a criminal act, but it also is grounds for discipline, and so it's something that can cause you to lose your real estate license. And in Illinois, we have sanctions, like a licensee, or the licensee that is engaging in discriminatory behavior. Well, once they've been found guilty in either a civil or criminal proceedings related to fair housing violations, the state law requires that the state immediately suspend or revoke that individual's license unless the person is still in the appeals process. But once you exhaust all of the appeals related to the finding of guilt, once those appeals are exhausted, well, the law requires that that individual's license be immediately revoked or immediately suspended. And so we have to be careful and make sure that we're following all of the fair housing rules and laws. And then if you're a member of the board, if there's been an order by an administrative agency and the finding of discrimination by a licensee, the real estate board can also penalize a licensee for engaging in discriminatory practices. In addition to the federal and state laws, as I had mentioned, we have cities or municipalities and villages in the state of Illinois that also have rules that they've enacted and ordinances that they've enacted. And the laws are enforced on a local level, and a lot of times the local laws will take precedence over a state or federal law if it's more restrictive. Whatever is most restrictive is what would govern, as long as it's constitutional. When a local law substantially is equivalent to a federal law, it's going to govern. And again, many local laws are stricter than and broader than the federal and state laws, and they would govern. The first law that was enacted in the United States to deal with civil rights was the Civil Rights Act of 1866. It was the first federal anti-discrimination statute. And what it did was prohibit discrimination based on race in the purchase, the lease, or the transfer of real property or personal property. And this is without exception. There's no exceptions to this rule, and there never has been since the passage of the law in 1866. And this law worked so good and was so effective that it lasted for 102 years. And ultimately, over time, the U.S. Supreme Court expanded the definition of race to include ancestral and ethnic characteristics, including certain physical or cultural or linguistic characteristics that are commonly shared by a group with a common national origin. And so it's important that we understand that as well. Now, as I mentioned, the first law was passed in 1866, and the next law that was passed was in 1968. Because between 1866 and 1968, there was still a lot of discrimination. We had laws that were separate but equal, Jim Crow laws, and we had a lot of people that were immigrating to the United States from various other countries. We had a lot of Jewish immigrants, a lot of Italian and Irish and Polish, and a lot of immigrants coming from all over the world. And when they arrived in the United States, they were not treated very well, and they were discriminated against at a high rate. And so in 1968, we added religion and national origin along with color and race, and that is what the protected classes were in 1968. The Title VIII of the Civil Rights Act of 1968 prohibited discrimination in the sale or the lease of residential property for race, color, religion, and national origin. And that's, again, the Title VIII of the Civil Rights Act of 1968, race, color, religion, and national origin. But at this point, there were still people that were discriminated against with respect to housing and choice and options for housing. And so in 1974, they added the Housing and Community Development Act, and it added discrimination based on sex. And what we're talking about here is gender. At the point of 1974, women were still discriminated against at a very high rate. And so the Housing and Community Development Act was enacted to help prevent women from being discriminated, and so that they can have housing of their choice, and they can be provided financing for housing of their choice as well in the purchase transactions. Well, even in 1974, after the passage of the Housing and Community Development Act, there were still classes of people that were discriminated against. And so in 1988, there was the passage of the Fair Housing and Amendments Act. The Fair Housing Amendments Act in 1988 added additional protected classes for people that had disabilities and for people that have children that occupy the household that had not reached the age of 18, which is majority in the state of Illinois. The Act also prohibits discrimination against individuals because of their association with an individual in a protected class. And so if I were someone that was married to someone in a protected class, well, because of that association, the discrimination against them would have an impact on me, and I would be included in the protection. And that's the Fair Housing Amendments Act of 1988. The federal fair housing laws are administered by the Fair Housing Act, are administered by HUD, the Department of Housing and Urban Development. HUD establishes the rules and regulations that further interpret the practices affected by the law, and HUD distributes an equal housing opportunity poster that is required to be prominently displayed at every real estate office. HUD basically creates the definitions of what would be considered to be housing. And housing, by HUD's definition, is a dwelling which includes any building or part of a building that's designed for occupancy as a residence by one or more families. This includes single-family homes, condominiums, cooperatives, manufactured housing, or vacant land by where they're going to, at some point, build a residential structure. Familial status is, again, the presence of one or more individuals that have not reached the age of 18, and they live with a parent or a guardian, a foster parent, a grandparent. Those would all be included in familial status. Now, familial status also includes a pregnant woman or a parent with temporary custody of a child, or someone that's seeking foster care status for a child would also be included in the definition of familial status. Disability, by HUD's definition, includes any physical or mental impairment that would substantially limit one or more of an individual's major life activities: talking, hearing, walking, those kinds of things are considered major life activities. Dressing or clothing yourself, bathing yourself. And individuals that have AIDS are included in the definition of disability. People that are current users of an illegal drug or a controlled drug substances are not protected, but if they're a user of an illicit drug and they've admitted themselves to a treatment program, they would be included and covered by disability. Now, those that are participating in alcohol recovery programs are also included in the definition of disability. But if you're a current user of an illicit drug or a current abuser of alcohol, you would not be included unless you're in a treatment program. Now, when an individual may own a property, they may be required to allow the tenants to make reasonable modifications. Individuals with disabilities must be permitted to make reasonable modifications to a premises, but they would do it at their own expense. So if a tenant needs to have a ramp installed, or to widen the doorways, or to lower the light switches, or to make other modifications, the tenant would pay for those modifications. The owner would allow them to do it at their expense. Now, in new construction properties, in certain multifamily properties, the number of accessible units may be regulated by the federal law. The number, not only the number of accessible units, but also the usability requirements must meet the federal standards when you have a new residential construction. You have to comply with the current law. Now, there are exemptions to the Federal Fair Housing Act. But there are certain things that are never exempt. Racial discrimination is never exempt. Discriminatory advertisement is never exempt. Services that are offered through a real estate company are never exempt. The company, the real estate managing broker, the real estate broker, the leasing agent are never allowed to engage in discriminatory behavior at all. There's never an exemption. But there are exemptions for individuals that are owner-occupants. They're private citizens that are owner-occupants with no more than 4 units rented without the use of a real estate broker, or housing that's operated by a private club that might limit occupancy to its members. They would be exempt. Some continuation of the exemptions is where there's a sale or rental of a single-family home. Well, that would be exempt when the home is owned by an individual who does not own more than 3 such homes at one time, and who does not sell more than one every 2 years. Housing for older persons or mature adults. Well, if the housing accommodations are designed and set up for people that are 62 or older, or if they're going to be occupied by people that are 55 years of age or older, whereby at least 80% of the occupants are 55 or older, well, they're exempt from the Familial Status protected class. The Americans with Disabilities Act. Again, these are laws that were enacted so that people with disabilities can have suitable accommodations of their choice. And it requires that in employment situations and in situations where there's goods and services being offered, that people or companies comply with the Americans with Disabilities Act. And so if you have 15 or more employees, you have to adopt a non-discriminatory hiring procedure. If you're providing goods and services to the public, well, those goods and services must be accessible to individuals that might have a disability. And then building owners and managers have to be aware and make sure that they're in compliance with all of the federal, state, and local laws related to the Americans with Disabilities Act. It's best to advise a commercial client to seek services of an attorney or an architect and consult with someone that might specialize with the Americans with Disabilities Act before they might purchase a property or make renovations to a property. There are some important definitions that we must be abreast of with respect to the fair housing laws. Because there are certain practices that that some have engaged in the past, and we want to make sure that we're not engaging in them or the company is not engaging in them. One of them is blockbusting, really important. Blockbusting is a situation where it's encouraging people to list their homes for sale by claiming that there's the entry of a protected class of people into the community. An example would be if a real estate agent went door to door and said, hey, you know, the purple people moved in down the street. You better hurry up and sell and list with me. And they continue to do that. And over the course of time, they encourage a bunch of people in the community to sell the property as a result of the entry of the purple people or protected class into the community. The next important definition that we need to know is steering. Steering is where we're channeling people into or out of a specific area as a result of us thinking that these individuals would want to be in a specific area as a result of them being in a protected class. If I said, well, you know, if I had a purple couple come into the office, I said, well, let me show you some homes where other purple people live. Well, basically, I'm steering them to the area that I think that they should reside in, as opposed to asking them where they would like to reside. It's really important that we not make decisions for people and we allow them to make their own decisions. And steering is something that's really important that we understand, because people will ask us to steer them. And we have to make sure that we not violate the state law, federal law, and local laws. And so we may have to push back sometime. If someone's asking us to be in a particular area, then we would find them a home in that particular area. But we do not go out and choose what area someone might want to reside in. We must understand that in Illinois, we have the Illinois Real Estate License Act, and it prohibits us from influencing or attempting to influence by words or action a prospective buyer, a seller, occupant that may be looking for residential rentals in connection with the viewing of property or leasing of property. We cannot steer people or attempt to steer people or influence their decision so as to promote or tend to promote the continuance or the maintenance of racially or religious segregated housing. And so we have to make sure we're careful in that regard, and we don't engage in steering activities, even if someone asks us to steer. If someone were to say, can you find me a house in a good neighborhood? Well, we'll push back and say, well, you know, we need you to identify the neighborhood that you would like to reside in, because good neighborhood or anything similar to that is very subjective. And so it's better that we push them to give us the information and determine where they want to live, and then we find a property in that particular area. The laws do not allow for discriminatory advertisement. There's no allowance for discriminatory advertisement. No advertisement for any property to sell or lease or rent may include language that indicates a preference or a limitation. And so an example would be that we wouldn't do anything exclusionary. Inclusionary advertisement could be acceptable, but exclusionary advertisement could potentially get someone in trouble. If I said, as an example, great home for joggers. Well, great home for joggers, it's defining the people. If you're defining the people that the space is good for in the ad, it would probably be discriminatory. So great home for joggers, it's talking about the people, bad idea, and it probably will get you in trouble. But if I said great home near a jogging path in an advertisement, well, I'm describing the property and its proximity to an amenity. Great home near a jogging path would be acceptable. Great home for joggers would be unacceptable. The next thing is appraising. Race, color, religion, national origin, sex, disability, familial status are not factors that may be considered in preparing appraisals or any statement of valuation, and that includes a competitive market analysis. The racial or color or religious makeup of the community is not to be used to determine or substantiate value. Now, gender-specific advertisement. An advertisement that is gender-specific, such as female roommate sought, is allowed as long as the advertiser seeks to share the living quarters with someone of the same gender. Remember, you can never discriminate against race. There's no exception to that rule. But if you were seeking to have someone of the same gender to reside with you in your residential property, you would be exempt and would be able to do such. Redlining is another practice that is not allowed in local, state, or federal law. redlining is a situation where mortgage companies or insurance companies would refuse to issue policies to specific areas for reasons other than economic qualifications like credit of an applicant. Basically, it's where the mortgage company or the insurance company places a red line around a particular community and says, we're not going to lend or we're not going to insure any of the properties within the red line. All right. Now, there's the Federal Home Mortgage Disclosure Act. It requires extensive reporting for mortgage companies so to make sure that the companies are not engaging in the practice of redlining. And it's something that they do on an annual basis. And when there's a claim of discrimination, what's going to be determined and what's going to be looked at is the intent and effect. Unequal treatment of a person in the practice of unequal treatment of an individual that's in a protected class is considered discriminatory regardless of the innocent intent. The courts will analyze whether the effect of your actions created a chilling effect for potential buyers and renters, and that's what they're going to use in consideration of whether or not there was discrimination. And the response to the concerns of terrorism are very important as well, and we consider those as real estate professionals. Landlords and property managers have been developing new security procedures that focus on protecting buildings and residents. Definitely, since a lot of the things that have happened in the world, there's a lot more done at the federal, state, and local level to prevent terrorist acts and people from being subject to terrorism. The enforcement of the Fair Housing Act, the Office of Fair Housing and Equal Opportunity administers the Federal Fair Housing Act under the direction of HUD or the Secretary of HUD. And anyone may file a complaint with HUD within 1 year of the alleged violation. HUD also can initiate their own complaint. And of course, parties may elect to file civil action in federal court at any time within 2 years of the alleged discrimination. And of course, unlimited punitive damages can be awarded in addition to actual damages when there's a discrimination complaint and the finding of guilt. So far, we've basically discussed all of the federal laws. And the federal laws, when people are talking about the federal fair housing, they include race, color, religion, national origin, sex, familial status, and disability. Now we're going to talk about the Illinois Human Rights Act. Well, the Illinois Human Rights Act, basically we took the federal law and added additional protected classes. We like to think that they added a mimosa, and I'll explain that certainly in a second. But the Illinois Human Rights Act includes prohibitions that are specifically addressed in the Real Estate License Act of 2000, such as blockbusting. And prohibited acts, it is a civil rights violation for an Illinois licensee to engage in any act of discrimination on the basis of an individual's color, race, color, religion, national origin, sex, or familial status. And what we've done is, as I mentioned, we added a mimosa to it. That's marital status, unfavorable discharge from the military, a military status, order of protection status, sexual orientation, and age. That's our mimosa. It's not the one you drink for brunch. It's marital status, unfavorable discharge from the military, military status, order of protection status, sexual orientation, and age is the mimosa that we're going to add here in Illinois. And so the Illinois Human Rights Act basically says it's a violation to refuse to engage in a real estate transaction, alter the terms, conditions, or privileges of a real estate transaction, refuse to receive or fail to transmit an offer, refuse to negotiate, or refuse to represent that real estate is available. Represent that real estate is not available when in fact that it really is available. It's also discrimination or a civil rights violation in Illinois to publicize an intent to engage in unlawful discrimination or to offer, solicit, accept, or use or retain a listing of real property with knowledge that its unlawful discrimination is going to be employed by the owner. The Illinois Human Rights Act with respect to children says that the civil rights violation for an owner of real estate or a real estate licensee of any housing accommodations, it's a civil rights violation in any of these situations to require that a prospective tenant not have any one or more children under the age of 18. So it's a civil rights violation to refuse housing accommodations to people because they have children, basically, is what's established here. Or it's a violation to insert in any lease a condition that terminates the lease if one or more children under the age of 18 are ever in the family occupying the property. Persons with disabilities. Well, in Illinois, it's a civil rights violation to discriminate against any blind, hearing impaired, physically disabled individual with respect to the terms, conditions, or privileges of sale or rental of real estate, or to refuse to sell or to rent to a prospective buyer or tenant because the buyer or the tenant has a guide, hearing, or support animal or service animal. The state law does not allow the charging of additional fees. No additional charge may be added to a lease, a rental agreement, or a contract for sale because of an individual's use of a service animal. In the case of elderly persons in Illinois, well, once an individual reaches the age of 40, you enter into a protected class for age discrimination by the Illinois Human Rights Act. That individual that is 40 or above is considered elderly, and they're included in the protected classes that we have in the Illinois Human Rights Act. Exemptions. Well, the exemptions of the Illinois Human Rights Act are identical to the exemptions of the federal fair housing laws because the state constitution requires that the Illinois exemptions mirror the federal exemptions. Again, I kind of consider this how to discriminate 101. And in order for someone to lawfully discriminate, they, number one, have to be an owner-occupant. They have to live at the property, and they can not own any more than 3 similar properties. And they or a member of their family have to be the most recent occupant of the property. And of course, you can never have racial discrimination, and you can never advertise the discrimination. And the property cannot be sold or leased with a real estate broker. And the home cannot be sold or leased with a discriminatory advertisement. And again, it's got to be an owner-occupied property of no more than 4 units. And owner-occupied buildings of 5 or plus units are exempt. Remember, the most restrictive law is what would prevail, and so the federal law will prevail in this particular case. Private rooms in private homes occupied by an owner or an owner's family member are exempt. Reasonable state, local, and federal restrictions limiting the maximum number of occupants permitted to occupy a space are permitted. And generally, that's going to be based on fire code. And then rentals of rooms and housing accommodations may be restricted to persons of one sex, like male or female occupancy at a homeless shelter would be an example of that. Religious organizations may limit the sale, rental, or occupancy of a dwelling owned or operated by the organization to individuals of the same religion. If membership in the religion is not restricted on the account of race, color, or national origin. So you can't base it on any other protected class except for the fact that that individual be required to be a member of the same religion. Now, the Human Rights Act's anti-discrimination provision does not protect individuals who've been convicted of by a court of law of illegally manufacturing or distributing controlled substances. And appraisers may take in consideration any factors other than those based on unlawful discrimination like in the federal law. So appraisers cannot break the federal law or state or local laws and consider factors like race, color, religion, or national origin and when they're going to formulate their value opinion. Housing for older persons is also exempt as long as they meet all of the requirements. If it were set up for people that are 55 and over, where at least 80% of the people are over 55, or where if the people are going to be 62 or older, well, there's an exemption for familial status and in those particular housing arrangements for older persons. Coercion and threats. It's really important that we as real estate professionals understand that the Federal Fair Housing Act prohibits and protects, right? It protects owners and real estate licensees that might aid or encourage the enjoyment of open housing rights. So when there's a situation of threats and coercion or intimidation, not only against the consumer, but also the licensee working with the consumer, well, those things would be punishable by criminal prosecution in federal law, in federal court. Now, the implications for the real estate licensee are very, very important to understand. We have to adhere to the federal laws, but also to the state and local laws. And the federal laws are very important and just as important as the state and local laws. All parties deserve the same service and same standard of service and same access to accommodations of their choice. And HUD requires that its fair housing poster be displayed at any place of business where real estate is offered for sale or for rent. You have to post in a readily available to the public the fair housing poster. Professional ethics. Well, professional ethics refer to a system of moral principles, rules, beliefs, and standards of conduct. The code of conduct that was established by the National Association of Realtors and adopted as a code of ethics and standard of practice for its members is used in the real estate business throughout the country. And realtors are expected to subscribe to the strict code of conduct and adhere to all of the rules that are established by the National Association of Realtors. And that ends Chapter 21.